that the court had jurisdiction, territorial jurisdiction, because this occupied territory, including the West Bank and Gaza Strip and the West Bank, including East Jerusalem, they are within the territorial jurisdiction of the ICC. And then the prosecutor already announced that they have started investigations into the situation in Palestine. Inshallah, Dr. Umi will discuss further on this point. Now, my conclusion is that, so we know very well that the position and international law is very clear. East Jerusalem, including Sheikh Jarrah, is an occupied territory, not under the sovereignty of Israel. And all the Israeli laws on East Jerusalem are null and void. And Israeli courts have to respect the laws of the occupied territory, not their own laws. And the evictions or anticipated evictions of Palestinian families from Sheikh Jarrah are very clear gross violation of international law. In particular, the 4th Geneva Convention, and could even amount to war crimes and crime against humanity. But as you all know, Israeli never accept this clear position of international law, and they are adamant about pushing its own laws on the occupied East Jerusalem, including Sheikh Jarrah. And what makes the matter worse is, their own domestic laws are, as I have explained to you, discriminatory and unjust to Palestinians. And hopefully, the Supreme Court, very soon they are making a judgment, a ruling, would be wise enough to stand for justice and respect the basic human rights of Palestinians by not strictly applying the discriminatory laws. Otherwise, the conundrum of the case of Sheikh Jarrah would persist, and violence and clash would still be the rule of the day. And the ground situation is that Israel seems to be determined not to comply with international law. And USA is always helping Israel by hook or by crook. How is to solve this? Of course, there are ways and means to enforce international law. And at the same time, there are also limitations to these enforcement measures, enforcement means, especially the veto power in the Security Council. So that's why, what would be a new narrative? A new narrative in this also could be to use soft power rather than hard power. Soft power in the sense of people's power, the silent majority, those who love justice and hate injustice, okay? And to give pressure to their government, the government of Israel, the government of America, to their own government, to give pressure to them. So this civil society, very important, CSOs are very important, the peoples are very important, and also us, the academia is also very important. For us to widely disseminate what is right and what is wrong, what is just and what is unjust, and to adjudicate the silent majority. This is the new narrative suggested by me. Thank you very much. With that, I conclude my presentation. Wabillahi taufiq wal hidayah. Wassalamu alaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Prof. Kafur, for that very enlightening presentation. So from that presentation, I believe we can see that the position under international law is very clear. The position under international law is actually very clear. Perhaps the problem is not so much with the position under international law, but instead with the enforcement of international law. Okay. Perhaps one issue is about the enforcement of international law as well. Let us proceed with the second presentation, but before that, please allow me to introduce our second panelist. Okay, our second panelist is Dr. Fajri Matahati Mohammade. He received his Sarjana Hukum from the Faculty of Law, Universitas Gajah Mada. His LLM was obtained from the University of Edinburgh and PhD from the Ahmad Ibrahim Kuliah of Law, International Islamic University, Malaysia. Dr. Fajri is currently an assistant professor at the Department of International Law, Faculty of Law, Universitas Gajah Mada, while also serving as associate member at International Law and Maritime Affairs Research Unit, IIUM. His research interests revolve around the intersection between public, international law, and Islamic science. The title for his presentation today is The International Humanitarian Law, IHL, Challenges of Asymmetric Warfare. Okay, let us now proceed with the second panelist.
Okay, thank you very much. Wait, I'll share my screen first. Okay, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahi Rabbil Alameen. Assalatu wassalamu ala asrafil anbiya'i wal mursalin wa ala alihi wa ashabihi ajma'in. Amma ba'd. First of all, I'd like to thank Ilma for hosting such an amazing event, and also the participants. And yeah, also I would like to convey my great respect to all the other panelists. MashaAllah, I'm in one panel with my teachers. This is a great honor, and honestly a bit of pressure as well. Inshallah, in this session, I will be explaining about the international humanitarian law challenges of asymmetric warfare. And this is building up a bit on what Prof. Abdul Ghafur has explained before, but I'm focusing more on the context of the warfare itself. So let me begin by introducing international humanitarian law first, or IHL, we call it for short, yeah? Because not many people would be aware of what IHL is. So IHL, or International Humanitarian Law, it's the international law regulating the conduct of warfare, or we call it jus in bello. Jus in bello is as opposed to jus ad bellum. So jus ad bellum, there's another branch of laws of war, which sometimes the layman would be misunderstand, is the lawful reasons to wage war. So when can you or can you not go to war? That's a different law. Yeah. So IHL, it's about how law regulates the conduct of war. Yeah. So the lawful conduct of war. The idea is to humanize war as much as possible, which is why, you know, some people would say it's strange that the laws of war is called humanitarian law. So the idea is to humanize as much as possible by doing at least two things: to protect those who are not or no longer participating in the hostilities, and to limit the means and methods of warfare, or in essence, to make sure to minimize the harmful effects of war. Now, what needs to be understood is there is a difficult negotiation between necessity and humanity. This is something that armchair observers, meaning like people who are not actually very familiar with war, those who are not engaged in it, would probably sometimes have a hard time understanding this, because on one hand, we want, you know, we don't want victims, we don't want, you know, like people to die, especially when they are civilians. But if the law is too idealistic, it may become unrealistic. When the law is unrealistic, no one's going to follow it. So there are parts of IHL which requires very difficult negotiations and compromising, which will take a bit too long if I explain the whole thing, yeah. But essentially, I mean, one simple part to say, difficult to explain, is like, for example, civilian casualties. When civilians die accidentally, is that a war crime or not? It may or may not be a war crime, even if civilians really died. Yeah, this is where a principle called proportionality will have to be applied, which is very difficult and very unfortunate. But yeah, that's the reality. Otherwise, no one will accept the law. So So this is why, I mean, IHL is a very difficult law to apply. Now, before we proceed to discuss the issue of asymmetric warfare, there is this question I'd like everyone to think about. What if annihilation is the consequence of obeying the law, and survival can only be achieved by disobeying the law? What if this situation happens? What if this situation happens? I don't think, well, you know, when the question is this a difficult choice or not? Maybe it's a difficult choice to live with. But honestly, I don't think it's a difficult choice to make. It's an easy choice to make. Yeah. Because sometimes, you know, in law, in basics of law, you would learn like what happens in times of duress, for example. There's excuses and etc. But think about a situation where it's not just yourself. You know, usually in classes, we use explanations of what happens if someone attacks us. Now we're talking about the survival of you, your family, and your people. Don't just imagine how terrible it is, but imagine the stress and how it feels like when you're in that condition. Yeah, so think of a different gravity of the situation. Now, asymmetric warfare is warfare between parties with a significant gap in strength. I mean, it's normal that, you know, throughout history, there's wars between two parties. One is stronger than the other. That's quite normal. It happens all the time. But we say it's asymmetric when the gap is so big. It's so big, it doesn't look fair. It doesn't even look fair at all. These differences could be based on budget, logistics, supplies, weapons, technology, size of army, etc. Now let's, you know, an easy case study is the case at hand. The IDF, Israel Defense Force, last year they got 20 billions of US dollars budget, 20 billions of US dollars. They got up to 500,000 strength. And, you know, like there's civilians, alleged civilians, they have to go through compulsory military conscriptions, military trainings, and they're automatically in the national reserves. They have cutting edge technology. They have no economic problems, and like half the world, if not all, are supporting them, both in finance, logistics, supplies, and etc. And they could go anywhere they want. Yeah. Compared to the Al-Qassam is the Hamas's military wing. Compared to IDF's 500,000 strong. Oh, and by the way, let's not forget they have a navy. They have an air force. The Al-Qassam, they don't have that. They have been estimated to have 30 to 50,000 personnel. We don't know their budget, but we know Gaza is starving. That's what we do know. Gaza is starving. They're practically blockaded. And I mean, like in terms of weapons, I mean, they are the ones who not so long ago, maybe just a couple of decades ago, they were fighting with rocks. And now they're using improvised fireworks, as normal Finkelstein describes the missiles of Al-Qassam. They're improvised fireworks, you know, and you see with all the showers of rockets that Hamas has been shooting and Israel has been, you know, like begging for mercy in social media. How many victims are there? How many destructions are there? Very minimum, right? Compared to like one missile shot by an Israeli helicopter, compared with just one. You know, I mean, you see the difference. You see the difference, yeah? It's very huge. It's like to say it's a David versus a Goliath situation is probably an understatement. Yeah. So what we find ourselves with is that it becomes reasonably unrealistic for the disadvantaged party to fight fair against the advantaged party. You know, I mean, like think about it this way. In the conflict that has been happening throughout the end of Ramadan and over Eid, the Israeli army, they've been shooting with their air force. Yeah. They didn't dare to send any men. Probably they learned their a terrible lesson in Operation Protected Edge a couple of years ago. Yeah. But they shot from the air. Hamas, the Al-Qassam brigade, they do not have any anti-air capacity. They don't have any anti-air. Yeah. They literally to fight the planes with. Yeah. So in the end, this is what we're left with. It becomes inevitable to use tactics which are otherwise illegal. Yeah, it became in a state of asymmetric warfare. This is what usually happens. Yeah. Now, here are the commonly used illegal tactics. When I say commonly used, I mean commonly used in most asymmetric warfare. Yeah, not necessarily in the Israel and Palestine conflict. That's not necessarily what I'm saying. Yeah, because some of these it's not being used. First, targeting civilians deliberately. So first is this. Although in Israel, in the case of Israel, we can discuss a bit. We need more discussion here because like a vast amount of their civilians are militarily trained and in the national reserves, and B, they are actively participating in harassing the Palestinians in West Bank, Sheikh Jarrah, and in many other locations. Yeah, but that's beside the point. Yeah, so you see that adds more complexity to this issue. But targeting civilians, they're usually a disadvantaged army, which is like very disadvantaged. They have to resort to this to demoralize the enemy, so they would, reconsider whether they want to continue the war or not. Yeah. So make sure if they might consider the war too costly. Yeah. It's different if the armies are, like pretty much both capable of fighting, but not when it's asymmetric like this. Second, human shield. Human shield is when the combatants of the disadvantaged party, they are taking advantage of civilian places. They're taking advantage of civilian locations. Yeah, meaning like they make the enemy hesitate to shoot them because they're hiding behind civilians. This is very commonly accused towards Hamas, yeah? But honestly, I don't think this is the case in the case of Hamas. First of all, Gaza is one of the most densely populated cities in the world. Like wherever you go, there's always civilians. Or are we saying that they don't have rights to fight back? Wherever they go, they're civilians. Like, well, what choice do they have? That's one, yeah? And second of all, we've seen, this is why maybe, not that I'm, criticizing Prophet's speech here, but to say that it's apartheid and crime against humanity and war crimes, that's an understatement because, it's rare that we say that war crimes are understatement. Yeah? It's genocide. There are scholars who are arguing that this is genocide. Yeah. The Israelis don't care. They don't care that they're targeting civilians. So, if Hamas is deliberately using civilians as shields, it'll be pointless. So all they will lose is popularity if that's really what they're doing. Well, popularity is practically what's saving them right now. So I don't think that's the case. But it happens a lot, like in Iraq, especially in Iraq, happens a lot. The Fedayeen, the Peshmerga, there are reports how they are, using a lot of human shields when fighting against the Americans. Then perfidy. Perfidy is when a combatant disguises as a non-combatant, or to make it plain, they disguise themselves as civilians. Yeah, they disguise as civilians. Okay, so that they can approach the enemy without being attacked. And then when they're close, suddenly they start attacking, or maybe they do a suicide bomb. Yeah, this is a war crime. This is a war crime. But then comparing the weapons between both sides, this happens in many places as well, like in Iraq, in Afghanistan, in Syria. I mean, if you don't, like the enemies, they have abilities to attack from miles away. Yeah. I mean, and the only way for them to get close is like this. Well, first of all, in a lot of cases, when you're having a resistance army, making a dress code is probably not your priority. That's one. Although the Al-Qassam does have a uniform, but just saying that there's a lot of dimensions to be considered. But what's more is, otherwise, you can't come close. You can't come close otherwise. Yeah, which is why it's quite difficult. So yeah, these are among the dimensions, and also the use of certain types of weapons, like for instance, chemical weapons. Sometimes I have not heard of this in Palestine yet, but I think I've heard this case in Syria and I think maybe in Iraq. Yeah, but mostly Syria. Yeah. They make improved chemical weapons where they can get their own ingredients. Or in the case of Palestine, they're using very inaccurate rockets. But honestly, they used rocks before. If they had a better choice, surely they would use it. I believe that. Yeah, if only they had a better choice. So you see how difficult it is. Now, the easy question is, how do we manage the damage? First is by applying the principle of proportionality. The party of Hamas is, they don't abuse this. They should not abuse it by, doing too much. So they still need to consider proportionality. And so does Israel. They have to consider the same. But this is the easy question, meaning that this is, if we're micro-analyzing IHL. But I think the more difficult question is how to break the cycle of evil. Because all of this is a cycle of evil. The only reason why the disadvantaged party is doing illegal tactics is because they are given an unjust amount of violations in the first place. And because they're using these tactics, then they are retaliated by even more devastating attacks. Retaliated by more illegal attacks. So you see, it doesn't stop. Now, in the Palestine context, this is what many must remember, yeah? Because a lot of people are blaming Hamas in this, because they say Hamas started it first. Because they mistake an absence of war with the absence of violence. Even without weapons contacts between Hamas and the IDF, violence has been happening for decades. That a lot of us are bored of talking about this because it's just never ending. And suddenly Hamas is shooting a rocket or two, and then we're suddenly saying, oh, you're starting a war now. That isn't fair. I hope we appreciate the situation. Now, so what do we do then? Do we wait for one party to be annihilated for this to stop? Or do we make peace? And at what cost? Yeah, this is a very difficult negotiation, yeah. As a person who's enjoying, from our comfortable rooms, like some of us are blaming, the Palestinians for not supporting the two-state solution. But if we try to put ourselves in their shoes, imagine if, someone suddenly breaks into our house, claims part of it, but they're more violent than us. And then the peace deal is, okay, they can keep half of our house, or maybe 3/4 of it. Will we tolerate that? So it's a very difficult negotiation. Yeah? Now, Prof. Ghafoor previously mentioned there are the silent majority. We must voice up, and the academics also. There is also a strong BDS movement that boycott, divestment, and sanctions, which Israel actually has a minister to deal with this, to show how it's actually potentially very harming them a lot. But nonetheless, Yeah, I feel that it's a very difficult situation. Yeah, like it's been decades, and while there is a silent majority, there is also a rich minority. See how their diaspora is very rich. They're very powerful. Now, I honestly, wallahu alam, I don't see the end of this. I don't see the end of this. Although I pray that it does happen. But how many years has it been since the Walls case judgment, as Prof. Ghaffar explained? And while we wait, the cycle is going to continue. So this is the complexity that asymmetric warfare brings to the laws of war and its implementation. It makes it impossible, like almost impossible to stop, and it's only going to be deadlier and deadlier. It's an inevitability. Yeah, I'm sorry, I cannot come up with an answer. I guess yeah, it's an ongoing process to find a solution to this. Okay, so I guess that's all. I thank you very much for your kind attention. I give it back to the moderator. Jazakumullah khairan kathira. Assalamu alaikum wa rahmatullahi wa barakatuh.
Okay, thank you very much for that very enlightening presentation. Now let me introduce our next panelist. Wait. Let me share the screen first. Okay. Okay, our next panelist is Professor Dr. Muhammad Nakib. Dr. Muhammad Nakib is a Islamic University Malaysia. He obtained his LLB, his master, and his PhD from IIUM, truly IIUM. His principal research area is international law, and he has special research interest in international refugee law, international humanitarian law, international dispute resolution, international commercial law, use of force in international relation, and the law of the sea. With his 23 years of teaching and research experience, he has authored or edited 14 books and published over 80 book sections and articles in international and referred law journals. Professor Dr. Muhammad Nakib served as head of research and as deputy dean at Ahmad Ibrahim School of Law from 2017 to 2018. He is a member of the advisory board of International Law and Maritime Affairs Research Unit (ILMA) and Alternative Dispute Resolution (ARDU) at IIUM. His ongoing research project is entitled Formulating Legal Framework for the Employment of Refugees Towards Enhancing the Malaysian Economic Growth, a fundamental research grant funded by the Ministry of Higher Education, Malaysia. The title for the presentation of our next panelist is The Right of Return of Palestinian Refugees, Issues and Challenges. You can see from the picture, massive destruction. Okay, let us welcome our next presenter, Prof. Muhammad Nakib. Please proceed, Prof.
Thank you, Dr. Yazid. Let me just share my slides. You can see, right?
Yes.
Yeah, okay, good. Alhamdulillah. Bismillahirrahmanirrahim. Respected Dean, Prof. Farid, fellow panelists, distinguished viewers, Assalamu alaikum wa rahmatullahi wa barakatuh, and a very good morning to you all. This is the title of my presentation, that is the right of return of Palestinian refugees, issues and challenges. My discussion revolves around the questions. This is full screen. This is full screen.
No, it's not full screen. Not yet. You can click at the icon beside the minus.
Okay.
No, the one beside it.
Is that okay? I think. Oh, okay. Is this okay?
Okay, you can click the
Hello?
one. Yes. Yes. Thank you, bro.
Yes,
it's full screen now.
Okay.
Thank you.
Full screen right now.
Yes, now it's full screen.
Oh, okay. Again. Okay. So my discussion revolves around the following points. Who are Palestinian refugees? From where are they originated? Is Israel responsible for their creation? If so, Israel must make good the wrong done. How that can be done, how Israel can do that? Just let the Palestinian refugees to return to their ancestral lands. And they have, of course, the Palestinian refugees have the right to do so, although Israel unjustifiably dispute that. But the fact is the Palestinian refugees do have the right to return. Now, let me first to define who are Palestinian refugees. Palestinian refugees are defined as persons whose normal place of residence was Palestine and who lost both homes and means of livelihood as a result of the 1948 conflict. This definition is given by the United Nations Relief and Work Agency. History reveals that in 1948, the majority of Palestinians living in what is now the state of Israel become refugees. These refugees who were entitled to register for assistance with the United Nations Relief and Work Agency are fully encompassed in this definition. However, the definition does not encompass large number of refugees who fled under the assault of Zionist forces before the start of 1948 war. It also does not include Palestinians who become refugees following the 1967 war, regardless of whether they had been granted citizenship elsewhere. Therefore, UNRWA revised the above definition several times, changing the eligibility requirements to be a Palestinian refugees. Palestinian refugees include the descendants of the refugees, regardless of whether they had been granted citizenship elsewhere. Now, estimates of their number vary. According to the United Nations Relief and Work Agency, there are more than 5 million registered Palestinian refugees who are scattered worldwide, living mostly in the West Bank, Gaza, Jordan, Lebanon, and Syria. And a small number of them live in Europe, and in other countries. However, Israel disputes that number. It claims that the actual number of the Palestinian refugees is inflated and that the Palestinian refugees cannot pass on their refugee status to their descendants. Israel's claim is inaccurate because under international refugee law, refugees can pass their refugee status to their children. The United Nations High Commissioner for Refugees Handbook on procedures and criteria for determining refugee status provide if the head of a family meets the criteria of the definition for refugee status, his dependents are normally granted refugee status according to the principle of family unity. Now, Palestinian refugees, as the term implies, originated from Palestine, and the map shows here the historic Palestine, the white thing. All were this territory was considered as Palestine, a land that has been ruled by many powers throughout history, including the Ottoman Empire. The Ottoman Empire ruled Palestine for about 4 centuries, during which Palestinians, including Muslims, the citizens or the population of the Palestine included Muslims, Christians, and a small minority of Jews. According to one estimate, 6% of the population were the Jews, 94% of the population were the Muslims and the Christians. They enjoyed rights and lived in peace for 400 years. The peace and the tranquility that was prevailing in Palestine came to a tragic end following the disintegration of the Ottoman Empire at the end of World War I. Most of the Ottoman territories were divided between Britain, France, Greece, and Russia. British occupied Palestine in 1917, and since then, the operation forced displacement and expulsion of Palestinian people from Palestine started. Now, the occupying power gives Zionism the opportunity to pursue its project to build a national home for the Jewish people in Palestine, as promised by the Balfour Declaration of 1917. The photo here shows Mr. Balfour's photo, and then his declaration is there. It is not clear why did Britain commit itself to the Zionist project of establishing a national home in Palestine and ignored Palestinian aspiration. What is clear, however, is that, as some writers suggest, the aim was to keep Jews out of Europe and settle them in Palestine, taking into consideration their religious root. Now, emboldened by the Balfour's promise, European Jews began to migrate to Palestine. The immigration process expedited when the League of Nations established a British mandate for Palestine, which placed Palestine temporarily under the British administration. This is the photo of the document for British mandate for Palestine. Now, the mandate implemented the Balfour Declaration, as by early 1930s, Palestine witnessed rapid increase in the Jewish population and the expulsion of thousands of Palestinians from their villages and towns. Now, the immigration of European Jews intensified from 1933 until the end of World War II and beyond. During the British administration, numerous wars took place between Jews and Arabs. Arabs fought Arabs, and sometimes both fought the British, which caused displacement among the Palestinians. Despite communal violence, European Jews continued to migrate to Palestine with little or no obstacles, and the Zionists helped them to be settled in the emptied homes and towns of Palestinians. This process slowly but surely changed the demography of Palestine in favor of Jews, as is evident in this particular slide there. Although towards the end of its administration, British did adopt a policy to slow down immigration of Jews to Palestine, but faced with revolt. Now a civil war broke out following the adoption of the United Nations General Assembly Resolution 181 of 1947, recommending the partition of mandate Palestine into two states, one Palestine, one Israel. So that war ended the British rule in 1948 and led to the establishment of the State of Israel in that particular year, and the report of the establishment of the State of Israel was reported in the Palestine Post. You can see here that Palestine was there before Israel came into being. So after its establishment as a state, Israel continued oppressing Palestinians, as Prof. Ghafoor highlighted earlier, that the oppression is continuing until today, forcing the Palestinians directly or indirectly to leave their homes and towns while allowing foreign Jews to settle in Palestine. What Israel has done in relation to Palestinians fit in within the meaning of ethnic cleansing and even apartheid, as was highlighted by Prof. Ghafoor earlier. This is the view of the Palestinians and the majority of the people around. You can see the map, how it changed. This is historic Palestine, and this is the 1947 partition plan, dividing Palestine into two states, one Israel, the other one Palestine. And that this was the result of the 1967 war. And then at the end you can see, let me, if I can go there, but I'm not so familiar. So at the end you can see we have a little territory left for Palestinians right now. So Israel claims Palestinian refugees left their homeland voluntarily during the war of 1948. And therefore it is not responsible for the creation of the refugee problem. Israel claims is inaccurate and baseless. There is considerable documentary and historical evidence, as confirmed by both Palestinian and Israeli historians and other sources, to show that the majority of Palestinian refugees left under the threat of organized violence and fear for their lives, and in some cases were expelled at gunpoint. Now, in we have, document showing that Israeli top officials conversed with each other, stating that the only way to establish a national home for Jews is to expel Palestinians from their homes and towns and send them to the neighboring countries. So that that is well documented. So Israel first expelled Palestinians and then legislated laws to bar them from returning, and then those laws, I think Prof. Abdul Ghaffur explained them, the absentees property law of 1957 and the prevention of infiltration law of 1954. These laws were explained by Prof. Ghaffur, and I am not going to touch on that. Even if what Israel says that that Palestinians had left their homeland voluntarily. Even if that is correct, which is not, of course, this would still not relieve Israel of its responsibility for the creation of the refugee problem. It also does not negate their status as refugees or their right to return to their homes as prescribed by international law. The right to return also persists even when sovereignty over a territory is contested or changed. So what Israel has to do is to now, Israel has committed by creating Palestinian, by reducing Palestinian as refugees or by expelling them, Israel has, to become refugees, Israel has committed an internationally wrongful act for which it is, of course, responsible. As the Cairo Declaration of Principles of International Law on Compensation to Refugees provide that since refugees are forced directly or indirectly out of their homes in their homelands, they are deprived of full and effective enjoyment of all articles in the Universal Declaration of Human Rights that presupposes a person's ability to live in the place chosen as home. Accordingly, the state that turns a person into a refugee commits an internationally wrongful act, which creates the obligation to make good the wrong done. By creating refugees, Israel has committed an internationally wrongful act, and it is responsible to make good the wrong done. It has to adhere to the remedy of restitution, that is, restore Palestinian refugees to their original position, that is, to allow their return to their homeland. For those refugees who are not willing to return, provide them with the necessary compensation so justice can be done. Right of return is a principle of international law drawn from Article 13.2 of UDHR, Universal Declaration of Human Rights, and Article 12, Paragraph 4 of the International Covenant on Civil and Political Rights. So this right is available to all refugees, including the Palestinian refugees. The United Nations General Assembly has confirmed this by stating that the Palestinian refugees wishing to return to their homes and live in peace with their neighbors should be permitted to do so at the earliest practicable date, and that compensation should be paid for the property of those choosing not to return and for the loss of and damages to the property which, under principles of international law or in equity, should be made good by the government or authorities responsible. Now, Israel, however, contends that United Nations General Assembly Resolutions 194 is not binding in international law. Therefore, Palestinian refugees do not have a right of return to their homeland. It is true that UN General Assembly resolution is mere recommendation as per Article 10 of the United Nations Charter, but Israel must remember that the right of return is a fundamental human right found in treaties, as in Article 12.4 of the ICCPR, which provides that no one shall be arbitrarily deprived of the right to enter his own country. Furthermore, the right of return or voluntary repatriation, as referred to by the United Nations High Commissioner for Refugees, is the preferable and most durable solution for the refugee problem. So the Committee on the Elimination of Racial Discrimination says that under Article 5D2 of International Convention on the Elimination of Racial Discrimination provides that states have an obligation to ensure all refugees and displaced persons have the right to freely return to their homes of origin under conditions of safety, and to have restored to them property of which they were deprived in the course of the conflict, and to be compensated appropriately for any such property that cannot be restored. Now, Utant, the then Secretary General of the United Nations, while pleading for the Palestinian refugees, stated that people everywhere, and this certainly applies to the Palestinian refugees, have a natural right to be in their homeland and to have a future. Now, the right of return makes no sense to Palestinian refugees unless it is enforced. To enforce these rights, the international community must pressure Israel to honor its international obligations. Israel's failure to respect Palestinian refugees' right of return is a flagrant violation of international law. The international community must show solidarity with Palestinian refugees and demand that Israel respect their right to return. It is time to put an end to the injustices that have been inflicted upon the Palestinians. For over 70 years, Palestinians have endured foreign occupation, exile, oppression, denial of national identity, and racism. The injustices inflicted on the Palestinians in general and the Palestinian refugees in particular must end. Their right of self-determination has to be restored, and their basic right of return has to be implemented. Now, Israel's conduct that generate refugees are illegal under international law. That is my conclusion. So the refugees have the right to reverse those illegal acts, that is to return to their. Israel must respect that right. For a just solution of the Israeli-Palestine conflict would not be possible. The right of return of Palestinian refugees is based on law, justice, and morality. Israel should uphold international law. Let the injustice be reversed by reaching a lasting solution to the plight of Palestinian refugees. After all, there can be no lasting solution to the Palestinian refugee crisis until Israel respects Palestinian refugees' right to return. I fully agree with Prof. Ghafoor with his conclusion that we should use soft power rather than hard power, because violence and conflicts and wars bring us to nowhere. So the best way to settle this and get the right of the Palestinian refugees implemented is through pacific means. With that, thank you very much. Hello?
Yes. Okay, thank you very much for the enlightening presentation. Okay, Prof, can you stop the sharing function?
Sure. Yes, Alhamdulillah, thank you.
Okay, thank you for that very nice presentation. As you can see from the presentation, justice must be for all. Okay, when we talk about justice, we must ensure justice for all, regardless of their origin, religion, background, and all. While the Jewish people always talk about justice for them, they often forget about others, including the Palestinians. If we were to look at history, for more than 400 years, Malaya, which later became Malaysia, used to be under various controlling power. We used to be under the Portuguese, under the Dutch, and then under the British, and for a short period of time, we were under the Japanese. After World War II, we see many countries receiving independence. But on the other hand, for people in Palestine, we see that after World War II, situations start to become much worse for them on daily basis. So it's the opposite. While the world is getting better after World War II, the situation become worse for the Palestinians since World War II, since the end of World War II. Okay, let us proceed with the presentation of our next panelist. Allow me to introduce our next panelist. Our next panelist is Dr. Ummi Hani. Dr. Ummi Hani is a senior lecturer in the Faculty of Law, University Technology Mara, where she has been a faculty member since 2008. She graduated from University Technology Mara with a Bachelor of Law in 2004, completed her Master of Advanced Study in Public International Law at Leiden in 2007, and she received her PhD in Law from University of Leeds in 2017. She was admitted to practice as advocate and solicitor in the High Court of Malaya in 2005. Her research interests lie in the area of international law and cyber security. Dr. Ummi, please proceed.
Okay. Assalamualaikum. Am I audible?
Yes.
All right. Okay. Assalamualaikum and good morning. Thank you for inviting me to speak today. The recent war on Gaza began from 10 until 21 May this year. Around 4,360 rockets were fired towards Israel from Gaza, in which Israel's air defense system intercepted 90%. 13 people were killed, including 2 children in Israel, and 200 Israelis were injured. Meanwhile, Israel 100 air and sea strikes on Gaza. The Israel Defense Force destroyed the Al-Jala building in Gaza, which housed Al Jazeera and Associated Press journalists. As a result of the violence, 256 Palestinians, including 66 children, were killed. In addition, more than 1,900 Palestinians were injured. At least 72,000 Palestinians have been displaced. Today, the Israel-Palestinian conflict has claimed the lives of 14,000 people since 1987. Human Rights Watch had documented excessive and disproportionate force by Israeli authorities, including the deliberate targeting of civilians and civilian infrastructure in the 2021 Gaza war. Unfortunately, the cycle of impunity, death, and destruction will continue unless the international community addresses the accountability of the parties to the conflicts. Therefore, in my presentation today, I would like to briefly examine the international criminal justice responses to Israel-Palestine conflicts, particularly the 2021 war on Gaza. Now, the objective of the international criminal justice system is to ensure accountability for serious crime such as genocide, crime against humanity, torture, war crimes, and crimes of aggression. The international community has a direct interest in dealing with these crimes as they threaten international peace and security. Furthermore, the victims of these crimes may be denied justice at the domestic level due to a weak criminal justice system or the lack of political will to investigate and prosecute crimes. As a result, there is impunity as the perpetrators are not held accountable and continue to hold positions that allow them to commit more crimes. Therefore, the international criminal justice system is the last resort to bring the perpetrators to justice and to provide reparation to the victims. Now, according to Professor Antonio Cassesi, international criminal law deals with the darkest side of humanity. Therefore, it takes more than a single response to address various aspects of international criminality. States can use several mechanisms to deal with grave international crimes, including, firstly, the International Criminal Court, hybrid courts, the exercise of universal jurisdiction, the Truth Commission, and human rights monitoring and documenting initiatives. I will now examine how states can use these mechanisms to get justice for the victims. The first mechanism is the International Criminal Court. It has the jurisdiction to investigate and prosecute genocide, crimes against humanity, war crimes, and since 2018, the crime of aggression. The ICC does not replace the national criminal justice system. It only comes into play when a state is unwilling or unable to investigate or prosecute international crimes genuinely. Now, the ICC may exercise its jurisdiction over crimes committed on the territory of a state party or by a national of a state party. A state that is not a party to the statute may make a declaration to accept the court's jurisdiction. In addition, the Security Council may refer a situation to the prosecutor for investigation. Now, on 5th February 2021, the ICC's pre-trial chamber decided by a majority that it may exercise criminal jurisdiction in Palestine. The former ICC prosecutor, Fatou Bensouda, announced the initiation of the investigation covering crimes that are alleged to have been committed since 13 June 2014. This decision contributes to the application of the international criminal justice system to Palestine. For instance, the ICC confirmed Palestine, which joined the court in 2015 as a state party to the Rome Statute. The ICC decided that there's no need to inquire whether Palestine fulfills the requirement of statehood under international law, as the United Nations Secretary General Assembly accepted Palestine instruments of accession. The court also ruled that its territorial jurisdiction extends to Gaza, and the West Bank, including East Jerusalem. These are territories that Israel has occupied since 1967. The pre-trial chamber relied on the right of self-determination to determine its territorial scope in Palestine. The court notes that the International Court of Justice has recognized the Palestinian right to self-determination within the occupied Palestinian territory in the legal consequences of the construction of a wall advisory opinion. This position is also in line with various resolutions adopted by the General Assembly and the Security Council, which recognize the right of self-determination of the Palestinian people. Therefore, states are obliged not to recognize measures aimed at changing the demographic of the Palestinian territory. Now, the decision of the ICC paves the way for the investigation of war crimes against people living under occupation. This decision is also crucial as the ICC acknowledges the reality of the victims in the occupied territory. The court rejected the arguments that it should not exercise jurisdiction as the prosecutor's request entails political consequences. This decision is essential as the victims in the occupied Palestinian territory should not be victimized twice. It shows that the Palestinians are not outside of the protection of the international law. Furthermore, the ICC determines individual criminal responsibility and not the responsibility of states under international law. Now, the prosecutor is satisfied that there is a reasonable basis to initiate an investigation in Palestine. Among the criminal activity that falls within the investigation scope is the establishment of Israeli settlements in the occupied Palestinian territory. Specifically, the prosecutor concluded that there is a reasonable basis to believe that members of the Israeli authorities have committed war crimes by transferring Israeli civilians to the West Bank since 13 June 2014. The investigation also includes Israelis' conduct in Operation Protective Edge and the Great March of Return protests. During the Operation Protective Edge in 2014, more than 2,200 Palestinians were killed, including hundreds of children. About 18,000 homes were destroyed or badly damaged, and more than 100,000 Palestinians were rendered homeless. On the other hand, 5 civilians were killed in Israel, including a 4-year-old boy, due to rockets and mortar shell fired by Palestinians. Now, the prosecutor is satisfied that there is a reasonable basis to believe that Hamas and other Palestinian armed groups commit the war crimes of intentionally targeting civilians and civilian objects, using civilians as human shields, and inhuman treatment. Now, how about the 2021 war on Gaza? The former ICC prosecutor had voiced her concern about the violence in Gaza and the possible commission of war crimes under the Rome Statute. She also confirms that the prosecutor's office will investigate all sides and all the facts and evidence to establish individual criminal responsibility. Now, according to the Palestinian Declaration, the ICC can investigate crimes committed in the occupied Palestinian territory from 13 June 2014 onwards. Therefore, the investigation includes the 2018 Great March of Return incident and the 2021 war on Gaza. Now, there are several challenges that the ICC prosecutor will face in probing the situation in Palestine. The first challenge is to overcome the attempts to delegitimize the court. Israel and the US opposed the exercise of the ICC jurisdiction. Israel has called for sanctions against the ICC to pressure the court from investigating. The US is currently facing the possibility of its national being investigated by the ICC for the alleged war crimes and crimes against humanity committed in Afghanistan since 2003. In 2019, the pre-trial chamber rejected the request by the prosecutor to open an investigation in Afghanistan. The pre-trial chamber held that the investigation would not serve the interest of justice, as the chance of success was low, and the lack of cooperation from Afghan and the US. However, on appeal, the ICC authorized the investigation as Afghanistan is a party to the Rome Statute. Also, the preliminary examination showed reasonable grounds to believe that war crimes had been committed in Afghanistan. This decision was made despite attempts by the US to discredit the court. The US reacted by cancelling the ICC prosecutor's visa, imposing economic sanctions and traveling restrictions against ICC lawyers, investigators, and journalists. Now, nevertheless, the recent decision of the ICC affirms that it can overcome geopolitical challenges and constraints. The ICC prosecutor has assured that the ICC is bound by a non-partisan approach and work for both Palestinians and Israel victims. Now, the next challenge is to ensure the success of the investigation. The prosecutor faced several difficulties. Firstly, the court has limited resources, despite its heavy workload. Secondly, states may refuse to cooperate with the prosecutor. It was reported that Israel controls all entry into the West Bank, including East Jerusalem and the Gaza Strip, and already denied access to UN Special Rapporteurs and the UN Commissions of Inquiry. Israel does not have an obligation to cooperate, as it is not a party to the Rome Statute. Furthermore, the political debate in Israel shows that Israelis' politics do not allow prosecution. For instance, the illegal settlers are not prosecuted in Israel because the settlement is considered lawful. According to a human rights organization in Israel, Yesh Din, only 4% of the investigation concerning suspected soldiers' offenses against Palestinians led to indictments. On the other hand, Palestine is obliged to cooperate with the ICC, as it is a state party. The ICC investigation includes Hamas and other Palestinian armed groups. Hamas is the key to facilitate the prosecution, as it controls Gaza and the access to evidence. Hamas is obliged to cooperate with the court, but may struggle to do so because it views the fighters as heroes and not criminals. Hamas spokesperson in Gaza welcomes the decision to investigate, but at the same time claimed that the resistance is lawful under international law, as they are defending the people. Now, the second mechanism is hybrid courts. Hybrid courts can be an option in dealing with a serious violation of human rights and international humanitarian law, since Israel is not a party to the Rome Statute, and Israel also questions the ICC's legitimacy. Hybrid courts blend the international and domestic institutional setting and applicable law. The judges apply domestic law that has been reformed according to international standard. Example of international tribunals are the Special Panels and Serious Crime Unit in East Timor, Special Court for Sierra Leone, Extraordinary Chambers in the Courts of Cambodia, Special Tribunal for Lebanon, and Extraordinary African Chambers. However, the establishment of hybrid courts in the Israel-Palestine context is difficult due to, firstly, the perceived bias toward a specific political and ethnic group. Human rights organizations have accused Israel of the crime of apartheid due to its discrimination against the Palestinians in the occupied territory. In addition, smooth coordination between national and international components is an obstacle. Israel imposes a military court system in the West Bank. It has jurisdiction over all offenses committed in the West Bank by the occupied Palestinian population, including traffic violence. Whereas in Gaza, Hamas runs a military judiciary. Now, moving on to my next point. The third mechanism is the exercise of universal jurisdiction by the national court. A national court may prosecute individuals for international crimes wherever they happen based on the universal jurisdiction principle. The Geneva Conventions 1949 allows states to exercise universal jurisdiction for grave violation of the Geneva Conventions. Now, due to the failure of the Israeli legal system to provide adequate remedies to Palestinians, the Court of Third States had in the past invoked universal jurisdiction to prosecute Israeli nationals who committed war crimes. For instance, on 10 September 2005, the court in the UK issued an arrest warrant for Major General Doron Almog for committing a war crime. He was accused of responsibility for the destruction of 59 houses in the Rafah refugee camp in 2002. The Brussels Appeal Court ruled on 10 May 2003 that it has jurisdiction to hear the Sabra and Chatila massacres. Unfortunately, the Supreme Court ordered the cessation of proceedings due to the amendment to the Belgian statute. Belgian Parliament amended its universal jurisdiction legislation due to the threat by the US to relocate NATO headquarters from Brussels to Poland. The UK court had to withdraw the arrest warrant against Almog as he managed to flee from the UK. Now, this example or these decisions reflect the difficulty in exercising universal jurisdiction to prosecute Israeli officials for war crimes. Now, the main reason for the lack of prosecution is obviously political oppositions from Israel and also the foreign states. Nevertheless, there are ongoing efforts in Sweden and Germany to investigate and prosecute individuals who have committed international crimes in Syria. Sweden became the first country to convict a member of the Syrian army for crimes in Syria. The accused was identified through a photo in which he posed with his foot on a chest of a dead victim. He was found guilty of violating the dignity of a dead body. Now, Sweden and Germany should also prosecute Israeli soldiers who have committed war crimes if they are present in the territory of Sweden and Germany. If they do not do so, then this is an obvious example of a double standard. Now, the next mechanism is the Truth Commission. Truth commissions are official investigation into a past pattern of abuse. Many countries use this device for societal healing. The Truth Commission can be brokered by the UN or set within a state. They are used worldwide, including in Latin America, South Africa, East Timor, Nigeria, and Peru. For example, when the apartheid regime fell in South Africa, the Truth Commission was established to uncover the crime of apartheid and reconcile South African society. Now, we can also find the concept of truths and settlements in customary law practices of many countries, including Palestine. Some scholars emphasize the need for reconciliation between Israelis and Palestinians due to both nations' proximity and various geopolitical considerations. However, the Truth Commission establishment depends on Israel and Palestine's willingness to admit and apologize for past violations. We can learn from the South African experience on the reconciliation efforts. Now, the next mechanism is the human rights monitoring and documenting initiatives. Human rights monitoring and documenting initiatives are established to collect evidence of violence to support criminal proceedings in national, regional, or international courts. One example of the initiatives is the UN International Independent Investigation Commission, established in 2005 by the Security Council. The commission investigated and gathered evidence into the murder of Hariri, ex-Lebanese Prime Minister. Another example is the General Assembly created a commission in 2016 to collect evidence of violations in the Syrian civil war to support criminal proceedings in national, regional, or international courts. And recently, the UN Human Rights Council... Yeah?
For me, maybe another 2 minutes more.
All right. Okay. Let me just explain my points a bit more. Okay. Now, civil societies and human rights organizations have undertaken the task to document human rights violation, and this would include in April this year, the Human Rights Watch had released a report alleging the commission of the crime of against humanity or apartheid by Israel in the occupied Palestinian territory. Now, to conclude my presentation, I'm sorry for the exceeding my time. The theme of the roundtable discussion today is Israel-Palestine conflict 2030, find new narratives. The international community needs to find a new narrative to end the cycle of violence and destruction arising from the conflicts. Therefore, states have to reanalyze the relationship between justice, peace, truth, and reconciliation in the aftermath of the 21 war on Gaza. Individual criminal prosecutions are not the only means to vindicate the right of the Palestinians. Thank you. Thank you for exceeding my time. Sorry for exceeding my time. Sorry. Stop sharing.
No problem. Thank you so much for that very interesting presentation and sharing. Let us now proceed with the final presenter for today. Okay. Let me introduce our final presenter first. Okay, our final presenter for today is Associate Professor Dr. Muhammad Isham. Dr. Muhammad Isham is an Associate Professor at Ahmad Ibrahim School of Law. He has written on public international law and Islamic international law. His publication notably include Principle of Distinction, Proportionality and Precaution under the Geneva Convention, the Perspective of Islamic Law, in addition to various other publications. Let us proceed now with the final presentation for today, and after that we will open the Q&A session. Please proceed.
Bismillahirrahmanirrahim. Am I audible?
Yes, you are audible.
Okay, thank you, Dr. Yazid, respectable the Dean of Kuliah of Law, Ahmad Ibrahim, fellow panelists, ladies and gentlemen. The title of the presentation is Israeli-Palestinian conflict, what should the Muslim state's attitude be? I take note that Palestinians are not only Muslims, they are also Christian Palestinians. They are also Palestinians who embrace other minor religions. And these are the outlines. I'm going to speak briefly about the concept of peace in Islam and refer to verses of the Quran as well as the Sunnah of the Prophet with regard to the right of self-defense and the concept of indivisibility of peace. And I will end by referring to the issue where 4 Muslim majority states have entered into normalization agreements with Israel. How can we trust Israel? Okay, if we refer to the Quran, there are many verses on fighting. There are many verses on jihad. And if we refer to the seerah or the historical situation during the time of Prophet Muhammad SAW, the Messenger SAW was involved in a number of battles. However, we have to understand that Prophet Muhammad never began any hostility. All the battles, all the wars that he was involved in were initiated by his enemies. Okay, and instead, Prophet Muhammad sent diplomats, letters to foreign nations, and he entered into treaties with many nations, including the Constitution of Medina. So, with regard to verses on fighting and jihad, all these verses must be read fully. For example, chapter 2, verses 190 to 193. Okay, these 4 verses were revealed at one time, and verse 190 prescribes that fight those who fight you. Unfortunately, sometimes there have been writers who refer to only verse 191 or only refers to verse 193 and came to a disagreeable conclusion. Okay, and we also have to take into consideration the causes of the revelation of the verses and its context. Okay, so basically, Islam is a religion that promotes peace. Islam itself comes from root word salama, which means peace. Now, in discussing how should Muslim states behave with regard to the issue of Palestinian and Israel, okay, we also have to understand that Muslim states today are members of the United Nations organization. They are parties to the United Nations Charter that prohibits unilateral use of force except in self-defense. And as Muslims, we have been ordered by the Quran, chapter 5, verse 1, O you who believe, fulfill all obligations. So the Muslim states must try to enforce the teaching of Islam within the framework of the United Nations system. Now, regarding what should be the attitude of Muslims when we are facing with hostility, Islam does not teach cowardice. Okay, Muslims must be brave and must be brave to fight injustice, must be brave to fight oppression. And if we refer to verses of the Quran, there are verses that expressly stated about the obligation, okay, to defend oneself under attack. It's not just a right in Islam, but it's also an obligation. We can refer to verses 22, 39 to 40, as well as chapter 2, verses 190 to 193. Now, the right of self-defense in Islam is not only the right of individual self-defense, but also the right of collective self-defense. I'm referring to a verse in the Quran, chapter 5, verse 2. O you who believe, help you one another in righteousness and piety, but help you not one another in sin and rancor. Okay, Imam al-Mawardi, the Shafi'i jurist, opines that Allah has turned to cooperation in righteousness and has connected it with cooperation in piety for him. Because in piety there is pleasure of Allah, and in righteousness there is pleasure of human beings. And whosoever gets both the pleasure of Allah and the pleasure of human beings is completely successful. So helping one another is not limited to only in religious matters only with fellow Muslims, but helping one another also include helping non-Muslims against oppression or injustice. Another reference would be Article 37A of the Constitution of Medina. This constitution was drafted by Prophet Muhammad SAW with the Arabs and Jewish tribes. There were two parts of the constitution. The first one, the earlier part, was drafted with the Arab tribes of Medina. This happened not long after the Prophet had arrived at Medina. And then the second part was prepared after the Battle of Badr. And this was agreement with the Jews. And Article 37A was in the second part. It provided that the Jews must bear their expenses and the Muslims their expenses. Each must help the other against anyone who attacks the people of this document. And not long after the Constitution of Manila was prepared to face the Quraysh in the Battle of Uhud, Rabbi Mukhayrik, the leader of the Jewish tribe of Sa'labah, fought together with the Messenger of Islam against his enemy, and he was martyred in that battle. In addition to the earlier authorities, the Quran also prescribed obligations on Muslims to assist one another in two other verses. Verse 872. But if they seek your aid in religion, it is your duty to help them, except against the people with whom you have a treaty of mutual alliance, and Allah sees all that you do. And another verse is chapter 4, verse 75. And why should you not fight in the cause of Allah and those who, being weak, are ill-treated and oppressed, men, women, and children, whose cry is, "O Lord, rescue us from this town, whose people are oppressors, and raise for us from you one who will protect, and raise for us from you one who will help." And another provision that I would like to highlight in the Constitution of Medina is Article 17, which prescribes that the peace of the believing Muslims is indivisible. No separate peace shall be made when the believing Muslims are fighting in the way of Allah. Muslims cannot say that the situation in Palestine is only concerning Palestine. It is actually concerning all Muslims wherever we are. And I would like to refer to the certain instances in 2020 where 4 Muslim majority states have entered into normalization agreements with Israel. United Arab Emirates did this in August 13, 2020, and this was followed by Bahrain, Sudan, and Morocco. Now, UAE stated that because of the normalization agreement, Israel agreed to suspend one resettlement project. But UAE, because of this agreement, will not be able to pressure Israel, whereas Israel only suspended one resettlement project. But that will not prevent Israel to continue oppressing the Palestinians. And this behavior would be contrary to the teaching of Ummah, the teaching of nation in Islam, chapter 21, verse 92, prescribes that verily this brotherhood of yours is a single brotherhood. And this is also contrary to the to Article 17 of the Constitution of Medina. Now, can we actually trust Israel? How can we trust Israel? Now, I'm referring to these verses, actually chapter 9 verses 1 until 29 were all revealed at the same time, but I just want to refer to only 4 verses that are in succession, verses 7, 8, 9, and 10. Although the verse is referring to the situation during the time of the Prophet, but I believe that this can also be applicable in our situation today. Verse 7 says, "How can there be a leak before Allah and His Messenger with the pagans, except those with whom you made a treaty near the sacred mosque? As long as they stand true to you, stand true to them. For Allah loves the righteous. How can there be such a leak, seeing that if they get an advantage over you, they respect not in you the ties either of kinship or of covenant. With fair words from their mouth they entice you, but their hearts are averse from you, and most of them are rebellious and wicked. The signs of Allah have they sold for a miserable price, and many have they hindered from His way. Evil indeed are the deeds they have done. In a believer they respect not the ties either of kinship or of covenant. It is they who have transgressed all bounds." Okay, from the presentation of the earlier panelists, Prof. Gafur, Prof. Nakib, and Dr. Umi, we have realized that Israel have violated many laws, have violated many agreements. Okay, and it is puzzling when we see after all these years of Israeli oppression, okay, there would be Muslim state who want to enter into normalization agreement with Israel. Although we know that this is because of the pressure United States of America could be imposing, but Muslim states must be brave in upholding justice. Okay, brothers and sisters, ladies and gentlemen, thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Okay, thank you very much for that. Thank you very much for that very interesting presentation. Now we have reached the end of the session, and now we'll have the Q&A session. So if the audience have any question, feel free to ask the question. Please start by mentioning your name and the panelist you are referring to. Unless you are opening the question to any panelist, then just mention your name and the question. Okay, please proceed if you have any question. Thank you. Perhaps the presentation was too crystal clear. Maybe the presentations were very clear, but we'll wait for a while in case there's any question from any of the participants.
Assalamualaikum warahmatullahi wabarakatuh. Can you hear me?
Waalaikumsalam, Izyan.
My name is Izyan Hazwani binti Ahmad. I'm from Office of the Children Commissioners Pakam. I just and this opinion with regard to the two-state solution, which is the one that propagated as well by our government. Thank you.
Okay, thank you for the question. Any panelists want to address this one first? The two-state solution.
Can you repeat again the question?
The question was about the view of the panelists concerning the two-state solution. Right now, some are proposing two-state solution as the solution for this conflict. So, is it feasible, or is it just a dream, or what are the view of the panelists concerning the two-state solution? Thank you.
If I may respond first.
Okay, please, Dr. Isha.
Okay, two-state solution was the idea from the very beginning when Israel was established, and the suggestion was made by the United Nations it was done without consultation with Palestinians, and it divided the land of Palestine into two. The better lands were given to Jews, and the lands for the Palestinians were the land that was not good. Okay, so and then the portion for the Jewish state is bigger, and for the Palestinian state was smaller. From my experience with some Palestinian officers in another webinar, I found that it seems that the Palestinians are now ready to accept two-state solution. Probably because their power is weakening. Probably the support that the Palestinians have received from other states are also weakening. I just mentioned just now, 4 Muslim states have normalization agreement with Israel. So because of that, probably they are willing to accept the two-state solution. But Israel, okay, although they may agree on two-state solution, but this is probably their strategy to buy times, so that later on they will pursue to establish the great Israel nation. And probably the Palestinians will also want the two-state solution, also to buy times, to strengthen themselves so that they can fight against Israel in the future. So I think two-state solution may be a temporary solution for both sides. But as a Malaysian who live in Malaysia, far from the situation in Palestine, I think it is best to leave the matter to Palestinians rather than for a Malaysian or for the Malaysian government trying to suggest solution, because we are not in their place. That would be my response. Thank you.
May I say something also? Dr. Yazid?
Yes, please proceed.
Yes. Okay, I fully agree with Dr. Hisham. I think he highlighted a very important point that in 1947, the United Nations, without consulting Palestinians, divided Palestine into two states. One is Palestine, the other one Israel. But Palestinians did not like that idea, although there were some Jews who agreed with that, who was willing to accept that. But Palestinians rejected it. But because, as Dr. Hisham pointed out, now the position of Palestinians are not in a great shape. They are weakened, sadly, so they may agree now on the two-state solution, but it must be based on that particular division. If that is based on that division, I think would be acceptable to the majority of the Palestinian. But one-state solution is not also a bad idea. It's a good idea. Why? Because, of course, provided that the Palestinian refugees are allowed to go to their homeland. Once refugees are allowed to go back and settle down in their native land, then the Palestinians become the majority. And Israel claimed to be a democratic country. Why Israel should be afraid of Palestinians returning to their homeland? Because if Palestinians return, then they may appoint the leader of the country, or may rename or may maintain the name as Israel, or may change it to Palestine, depending on the will of the people, on the will of the majority. But sadly, Israel is refusing to allow Palestinian refugees to go back to their native land, and making the one-state solution almost impossible. So the only option left is one-state solution, two-state solution. But whether whatever solution agreed upon, whether it is two-state or one-state, refugees' right to return must be implemented. But there are some fundamental issues standing on the way. The first one is how to get Israel to abide by its obligation under international law. Now, what Israel has done vis-a-vis the Palestinians may amount to a threat to peace or a breach of international peace and security. And the only body at the international level that is entrusted with the task to maintain international peace and security is the United Nations Security Council. But so the Security Council may take an enforcement measures against Israel to abide by its obligation to end occupation, to implement the Palestinian rights of return, Palestinian refugees' right of return. But the question is, the collective decision, an enforcement decision at the UN Security Council requires the support of the Big Five, including the United States of America. The question would be, will the United States support that type of coercive measures against Israel to abide by its obligation? Of course, so far, United States has shown no willingness to support that type of decision. And even if the U.S. supports a collective enforcement decision against Israel, now the question would be how to deal with the internal laws of Israel, as Prof. Ghafoor highlighted in his presentation, that Israel has adopted laws confiscating Palestinian lands and properties and depriving them of the right to return. How to get Israel to repeal those laws to facilitate the enforcement of international obligation. That is my view. I hope I have made sense.
Okay. May I also add something?
Yes.
Please proceed, Frederick.
Okay, thank you very much. This two-state solution, I agree with all that Prof. Nakib said and also Dr. Hisham. But two things I'd like to mention. First, regarding to the two-state solution, I think we should never forget that it's such an evil solution. I think we cannot understate this. It's an evil solution because we are forcing them to give up. Yeah, I think it's an unacceptable solution. So those supporting the two-state solution are only two kinds of people. One is those who are also equally as evil. Or second, they are those who also feel defeated. They feel, okay, fine. They are forced to accept this. I really agree with Prof. Nakib's idea, to have a one-state solution. And, why is Israel afraid? Now, however, there's one more thing I'd like to point out about this. South Africa faced the same dilemma in the past. When they discriminated the native Africans for so long, when they are afraid of democracy because they know who's going to lose. And they're afraid that they will retaliate. But I personally think in this case, hopefully, Muslims have treated the Jews very well before. We have treated them well before in the Ottoman Empire and even back until the time of Prophet Muhammad sallallahu alaihi wasallam. We can give them special autonomy. Palestine can give them special autonomy, as dhimmi, for example, in context of Siyar. this negotiation can be made. So there are peaceful solutions which can give the Jewish people their rights if they really want to live nicely. And they don't have to fear retribution. Just because they did it to the Palestinians, it doesn't mean the Palestinians would do the same thing. Because in the beginning, I was told that the Palestinians were accepting of these Jews. They were sympathetic at the beginning. Yeah. So other more fair and just solutions are available. They're all available out there. Yeah. So that's why I think there is simply no reason to support the two-state solution. Those who do are either just as evil, or they already feel defeated, that they end up being very pragmatic. That's my view. Thank you.
Okay, is there anything else from any of the panelists?
I think already discussed enough by panelists, three panelists.
Okay, thank you. Let us proceed with the question from the chat. Participant can also put their question in the chat box.
Okay. Let me reply to the first questions in the chat box. So, asking that whether Malaysia risk its soft power and influence in international fora, because Malaysia is now rejecting international law on issues such as refugees and joining the ICC. So my response would be that I would agree with the one who made the question, because Malaysia will definitely lose soft power and its influence in international fora. As far as the refugees are concerned, we refuse to adopt the refugee convention. So that's why we have a lot of problems with this refugee area. And also Malaysia refused to join the ICC, the Rome Statute, to join the Rome Statute. And this is also one Malaysia cannot argue for the Palestinians. Why Israelis are committing this international crime, whereas Malaysia is rejecting the Rome Statute of the International Criminal Court. So that's why I would agree with the one who asked the question. Thank you very much.
If I may add, right, in response to the question, the main reason we withdraw from our ratification from the ICC statute is because of political issues. And I think the decision to withdraw, it does not reflect the will of the people of Malaysia. I think what we can do right now is to educate the public more about the importance of international criminal justice system, especially the ICC, so that younger generation can change the current narratives. All right, so in line with the theme that we have. Thank you.
Okay, thank you for the answer. Okay, let us proceed with another question. This is a question from Nur Baizura. In your opinion, any panel, or if anyone want to proceed with this one, in your opinion, in general, what is our position as a Malaysian to help the Palestinian in overcoming or in giving support or to give solution to the Israeli-Palestinian conflict? In other words, the question is about the way forward. What can Malaysia do in order to show our support in settling this decades-long conflict? Any of the panelists, please proceed. How can Malaysian contribute? Is it through donation or protest or BDS, boycott, diverse sanction? Any comment from the panelists?
For me personally, the role of our society has been instrumental, especially in pertaining to the decision rendered by the International Criminal Court to start the investigation in the Palestinian territory, and we have submitted our opinion. I think some organizations in Malaysia were involved in the case as an amicus curiae. And then at the same time, as academicians, what we can do is that we can conduct more academic discussions so that the younger generation are more aware about the situation that happens in Palestine. Thank you.
Okay, another question from Siti Fatirah Ramli. Why does Hamas regarded as terrorists? Doesn't international law provide the right for self-defense? Any of the panelists want to reply on this? It is noted that some countries they designated Hamas as a terrorist group, while others some recognize Hamas. So basically, the question is about the designation of Hamas as a terrorist group. So the question is whether international law do not recognize the right to self-defense. So anyone want to comment on this? Maybe anyone?
May I answer this?
Sure, please proceed, Fajri.
Okay, thank you. Sorry for jumping in first because I just discussed this issue not very long ago. The one thing we need to understand about terrorism in terms of legal classification, there has been a very long debate on what is terrorism in terms of law. There are many critics that so many definitions, they don't work. The definitions are contradictory, self-defeating, and in the end, it ends up political. Like, for example, a critical analysis will show that according to the UK Terrorism Act 2001, the UK government committed terrorism when they invaded Iraq. So, it becomes a very problematic thing. When we see who is a terrorist, who is not a terrorist. Then we come to an anecdote, which is very common. One man's terrorist is another man's freedom fighter. Terrorism, us Indonesians, we fought against the British in 1945. And when we fought against the British, the New York Times called our warriors, our fighters, as extremists. It's common. So what I would say is Hamas is only regarded as terrorists by two kinds of people. First, probably those who don't know the big picture, because they don't know, probably. Because they see, suicide bombing, that seems extreme. But on the other hand, I see that there are quite a number of states that declare them as terrorists. It's because of their own political interest. Like Israel, they would never want to recognize the Hamas as a legitimate force because they have interest not to recognize it. And the United States as well, because they're an ally of Israel. So basically, that's the issue with the labeling of terrorism. So that's the issue with the labeling of terrorism. And a longer discussion on law and terrorism, it would be very difficult because it messed up so many different legal systems, including international law. This issue of terrorism, And I think the last question of does international law secure the right of self-defense? It definitely does. I mean, the question then is, are the requirements satisfied, and is it proportional? Maybe that's maybe it's not. But in any case, I think what Hamas is doing is legitimate self-defense. And I think many are recognizing that as well. Okay, thank you very much.
Dr. Yasid, may I add to the discussion?
Please proceed, Prof.
Yes, as for the earlier question, what Malaysia can do to assist Palestinians and their aspiration is to advocate the aspiration of the Palestinian to establish a sovereign state for themselves at the diplomatic forum. Malaysia can do that, and in fact, Malaysia has been doing that for years and years, but Malaysia can continue to do that. That promotion to establish a sovereign state for Palestine. Now, whether through two-state solution or through one-state solution, either one, depending upon the parties agreed, the disputing parties. The other question, as regard to the question relating to whether Hamas is a terrorist organization, I think I fully agree with Dr. Fajri that this is just a labeling done by some supporters of Israel and Israel itself. Hamas is not a terrorist organization. Hamas is an organization that fights for the liberation of Palestine. They are freedom fighters. And if we were to label Hamas as terrorists, then Israel should also be addressed as a terrorist state. Why? Because if Hamas send a few homemade rockets, Israel is bombing towns and villages of Palestine without discriminating civilian objects, military personnel, or civilian population and military personnel. So Israel should also be labeled as terrorist states. So, but we are not doing that. But Israel should not label, or no one should label the victim, that is Hamas in this case, who are merely fighting for their self-determination, and that is their basic right under international law. Do we have a right of self-defense? Do the Palestinians have the right of self-defense? Yes. The Palestinian claim, aspiring to establish a sovereign state, and that sovereign state has the right to use force in self-defense. Yes. I hope I made some contribution here to the question.
Okay. Thank you so much, Prof, for sharing the very informative explanation. Okay, we have now reached to the end of today's program. If you are to look at other countries, if you are to look at Malaysia, for example, in Malaysia we have more than 70 different races. Although the main race include the Malay, the Indian, and Chinese. In total, including Sabah and Sarawak, in Malaysia we have more than 70 races. Yet we are able to live peacefully with each other. Although we might have different color, different religion, different races, but we are able to live peacefully with each other. Definitely, we can see that in that area, in the Palestinian Israeli areas, there seems to be a non-stop conflict, and in the end, the one who suffer the most are always the innocents, the children, the women, the elders. So we should try to help to solve the conflict because this is for the best interest of everyone. It is feared that eventually this conflict will grow. For example, it can lead to a lot of hostility among Muslims country, and people are taking sides, and who knows where it will end. Maybe in the future this will lead to a major war between the Muslim nations and non-Muslim nations, or at least in the Middle East. So we are hoping that there will be peace there for everyone, so that all the children, the elderly, the women, the innocent can live a peaceful life. Okay, thanks again to all the participants, to all the panelists, to everyone for joining this event. I hope everyone managed to learn something new today. I myself managed to learn a lot of new things today. However, if there are any weaknesses in relation to this event, it was my fault alone from my own weaknesses and all. Let us end today's event with Tasbih, Farah, and Surah Wal-As. Okay, thank you everyone. Thank you for joining. I will end the session now.
Thank you.
Yeah, Assalamualaikum, everyone. Thank you very much.
Waalaikumsalam. See you.